Welcome, everybody. I'm John Haig. I am the co-director of the Mosavar Rahmani Center for Business and Government. We have a small group in person and evidently a relatively large group coming online. So the advantage to those of you who showed up is if you raise your hand, you get asked questions first. So that's a big advantage. Today, a couple things. We have with us Phil Verveer, Tom Wheeler, and John Salat. Each in their own right is like an incredibly accomplished civil servant in many ways. Tom was the FCC chairman at one point. John was the general counsel for the FCC and has worked in the DOJ as a litigator and is currently heavily involved in the Colorado Attorney General's office case bringing an antitrust suit against Google. Colorado seems to be one of the lead, maybe the lead state in bringing this forward. And then the main person today is Phil Verveer. And Phil actually has been an advisor to Tom at the FCC. He was also ambassador and U.S. coordinator for international communications and information policy. And that's the ITU, which basically sets a lot of global standards in the telecom sector. So a pretty significant, important role. And he also, I will get it right this time, signed the complaint that ultimately led to the modification of judgment against AT&T that broke up the AT&T Bell system in 1984. And so he and I have these, we've crossed paths at a distance because I worked at AT&T for 10 years. So with that, I'm going to hand it over to Phil. It's all yours.
John, thank you very much. It's a pleasure to be here. And to the unseen people online, we hope that we'll provide worthwhile entertainment during the lunch hour here. I am doing this in the midst of a three-part effort. And for those of you who were here last month, you know that Tom Wheeler indicated why we find ourselves in a situation in an industrial and economic commercial setting that is rather different from any that we've had in the past by virtue of the technological advances that we've seen, which in turn have given rise to new business models and also to rapidly shifting consumer preferences. And next month, John Salat is going to talk about the antitrust and related issues that digital platforms present to not only this country, but to the wider world. And just by way of noting briefly, the dynamism of this sector, in the last 24 hours, we've seen two important developments in the scheme of things. One, the district judge who presided over the Epic and Apple antitrust case declined to extend a stay during the outcome of appeals for the injunction she issued against Apple. Apple is now going to appeal that to the Ninth Circuit, but an important milestone passed yesterday in that case. And probably more significantly, the General Court in the European Union has upheld the European Commission's judgment against Google in the so-called Google shopping case and has upheld the $2.8 billion fine that the European Commission imposed on Google. Now, Google has an opportunity to bring this case to the highest court in the European Union, the European Court of Justice. But again, a very important milestone in the various questions about whether or not we have social controls that apply adequately and appropriately to the major digital platforms. So today I want to talk about not the structural issues, the concentration and antitrust type issues, but rather the issues that are brought forward by the negative externalities that these major digital platforms throw off. It is something that in a, let's see if we're making this work right, it is something that requires, I think, at the end of the day, in many ways, an effort at balanced judgments. So we have here the question of the 26 words that created the internet. That's the title of a book by Jeff Kosseff. It is argued that this title is a little bit excessive. The author himself didn't pick it out. I think he himself would acknowledge that it perhaps overstates matters, but it turns out it doesn't overstate matters by an awful lot. And this is what Kosseff, who's a professor at the U.S. Naval Academy in Annapolis, has said about this, that if you remove those 26 words from the U.S. Code, it would unravel the internet that we know today. That, I think, is absolutely accurate. It is not an excessive statement. But he also said that the open mic business model, which it has enabled, is a generator of the dynamic, communal, and vicious public square that we know today. That is social media and other forms of internet services. And the word vicious is also one that is difficult, I think, to quarrel with. So these 26 words become very, very important in terms of the world of digital platforms that we know today. Now, what are the 26 words? No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. So we need to think about what those words mean, because it turns out there's an awful lot of meaning tied up in those 26 words. Provider these days probably means, at least for our purposes, a digital platform, although it could mean more than that. It turns out the word user is very important, and we'll get into that in just a moment. The interactive computer service is probably what we mean today by the internet. And the question of publishers or speakers brings into relevance in the United States, the First Amendment and all of the jurisprudence that surrounds the First Amendment. And finally, provided by another, which turns out to be very important. If a third party is providing the content, the 26 words kick in. And what the 26 words do is they provide an unprecedented level of immunity for digital platforms, and as we'll see in a minute, for users as well. So, to be fair, we have to kind of stop and reflect that the Section 230 and its 26 words not only enable the open mic business with a lot of the negative externalities that we have to contend with today, but it also enabled the virtual communities that the internet has permitted. It's enabled the customer reviews that we see on Yelp and other services that are helpful to consumers. It enables the public comments that you see on the various posts, newspaper articles, and other things. And it's fair to say it enabled things like Wikipedia and YouTube and other services that are very much dependent upon third-party providers of this content. But again, as we've learned, the 26 words also enabled negative externalities, fairly serious ones. So, what does it do? It has created for platforms a level of immunity that's unprecedented in US jurisprudence. The platforms, as long as they are passive, as long as they don't do anything with respect to the content that they provide, are completely immune. And it turns out that our 26 words has had some significance elsewhere in the world, because the European Union's e-commerce directive of the year 2000 has a similar set of immunities for the completely passive digital platform. So you have a situation where if Facebook or Twitter simply accepts a post that someone else provides, it is completely immune from any sort of legal action. That's simply not true with respect to any other medium under US law. Secondly, we have the user immunity. And the user immunity basically means that if someone reposts or retweets or likes a post that some third party has already entered on a platform, that individual is also immune from any sort of legal action. And that sort of thing becomes very important if you think about the problems of defamation, or more especially, you see it really, I think, quite plainly in the context of cyberbullying, where some maladjusted person says something very unpleasant about a classmate, let's say, and then others pile on. Well, those others, if all they're doing is repeating what the first malicious post says, are also immune. So it's a way in which harmful information is spread. It becomes very important because some of the harmful information is not just disadvantaging adolescents. Some of it is doing a lot broader harm as well. But users themselves are immune if all they do is simply repeat something that they've already found online. Again, to be fair, it's also true that this enables a great deal of useful information. So when friends see a newspaper article or something else, somebody's comment that they think is useful and important, something that you'd find interesting, and they send it to you, they're also immune. So overall, we have, again, something that is really without precedent in our law. And then, with luck, we'll get to the exceptions. There are a whole series of exceptions to this immunity. So it's not, it is a blanket immunity, but subject to carve-outs or subject to exceptions. And that is very important in terms of the way that a lot of our policymakers are now thinking about the question of Section 230 and what to do about it. So what are the exceptions? One is violations of federal criminal law. So if a posting of some kind violates federal criminal law, no immunity. The second is intellectual property. That if you are engaging in violations involving someone's intellectual property, the fact that Section 230 is there doesn't protect you. The third thing is state laws, to the extent that they're consistent with the Section 230 arrangements. Again, this is something that it turns out I don't think is terribly significant in the scheme of things as a practical matter, but it is a further carve-out. We also have a carve-out for a particular privacy law, the Electronic Communications Privacy Act. It is a 1986 act. It is by virtually every fair assessment horribly outdated, and we can't seem to get it amended or brought up to date. But it's an important law, particularly an important law with respect to certain kinds of criminal activities, warrants the ability of the federal government to access digital files, and many would argue makes it too easy for the federal government to access digital files. But in any event, that also is a carve-out. And then finally, we have sex trafficking. Now, this is a relatively new amendment to the carve-outs. This was put into the law a very few years ago, after a lot of an awful lot of back and forth between people worried about the kinds of material that was showing up on the internet, including the ability of Section 230 to basically shelter those who are engaging in sex trafficking. And the platforms themselves who resisted these changes, as did a fair number of civil libertarians who are always worried about further inhibitions on free speech. This has proved to be a very controversial amendment. There are a lot of people who are experts in this area who claim it has done more harm for the supposed beneficiaries than it has good. And so it remains a kind of interesting and frankly continuing to be contentious issue. And that fact is instructive in terms of various proposals we'll get to in a few minutes about further carve-outs, about further amendments to Section 230. Now, the question is, how did we get here in the first place? Where did Section 230 come from? How did we end up with it? This gentleman is Senator James Exon, a Nebraska Democrat. I want you to think about that for a moment. A Nebraska Democrat. It's something that very, very few of us in this room are old enough to even begin to comprehend. But that's what Jim Exon was. And his concern was that he wanted to protect minors. He wanted to protect children from indecent or patently offensive speech. And those two phrases are important. Indecent or patently offensive were the kinds of phrases that he put into a proposed amendment to the Telecommunications Act of what turned out to be the Telecommunications Act of 1996. But in the bill as he had proposed it, it was the Communications Decency Act. And you can see why it would have had a name like that. Again, an effort to try to protect minors from particularly sexual content. Now, in addition to Senator Exon, we had two members of the House of Representatives who also were addressing this issue as well as somewhat wider issues. The man on the left is Ron Wyden. At the time, a member of the House of Representatives. He is today the senior senator from Oregon, a Democrat, and in fact, a rather liberal Democrat. And the man on the right is Christopher Cox. Chris Cox, at the time, again, a member of the House of Representatives. He went on to serve as the chairman of the Securities and Exchange Commission during the George W. Bush administration. So these fellows, in a way, were sort of an odd couple. They're politically about as far removed from one another as you could be in terms of the political spectrum. But they got together to try to work on a proposal that they have, as they've subsequently described it, it wasn't so clear in the legislative history because the legislative history is quite sparse, but a proposal to do two things if they could. One was to try to correct an existing anomaly in the law, something that was beginning to develop in the law. And the anomaly was this. There was one court case that found that a portal, at the time, a kind of closed or walled garden approach to providing content, that attempted to engage in some curation, attempted to engage in some editorial activity vis-a-vis the third-party posts that were appearing, was found liable, was found not to be immune from suit because they had participated, the company had participated in relatively minor ways, it turns out, but participated in trying to make the content available, in fact, more suitable for polite consumption. The second case involved another walled garden portal approach that made no attempt at all to moderate the content that was being submitted by third parties. And the court held it was immune because it simply was accepting this. It had no real engagement other than to let the portal be used. Some sense, sort of like a telephone system where the content was a matter of no consequence to the entity making the content available. So you had these two cases which, as the internet, the commercial internet, was beginning to emerge, and the commercial internet at this point was about 2 or 3 years old, but this was beginning to emerge. This was troubling, and they were trying to find some way to come to a complete and unambiguous set of decisions about how to contend with the question of third-party content being made available. And the second thing they were trying to do was to clean up troubling material on the internet. And certainly in terms of subsequent statements the two men have made about what their desire was, what they were trying to achieve, that has been an important consideration. And it is especially important because the 26 words that created the internet are followed by another provision in the same statute that says that if a digital platform engaging in good faith activities engages in content moderation, it decides not to include material, that it also is immune. So the immunity runs both to complete passivity, but also runs to efforts at content moderation. So in a sense, the platforms have it both ways. They can do nothing and be immune. They can engage in some content moderation and be immune. Now, we have both these provisions that are turning up at the same time in the same legislation. So what of course happens between the Senate and the House when this sort of thing happens is you go to a conference. And in this case, the conference didn't choose. It just stuck both of these provisions in. So the Exxon provision and what became Section 230 also entered into the law. These things were basically incorporated into the Telecommunications Act of 1996. The reality at the time was most people weren't paying any attention at all to these activities. They were sort of seen as kind of minor and not terribly relevant activities, proposals vis-a-vis the main proposal, which had to do with competition in the telephone business. This was an effort by the Congress of the United States to relieve John of the torment that he was experiencing as we tried to sort out the consequences of the AT&T divestiture, which at that point had been going on for 12 years. So nobody was paying a lot of attention, but the reality is, because of the Supreme Court decision the following year in Reno against ACLU, the Exxon provisions were thrown out as a violation of the First Amendment. But we were left with Section 230. We were left with the 26 words. And given the obvious significance that these 26 words have had in terms of the progress of the internet since, it's a kind of remarkably thin history. It sort of suggests the distinct possibility in the world of public policy of inadvertence. And in fact, Verveer's second law is that the explanation for almost everything is inadvertence. So you want to keep that in mind in terms of your future activities. On April 19th, 1995, Timothy Mcveigh bombed the federal building in Oklahoma City. It killed an enormous number of people, including a lot of children at a daycare center. It was, at the time, the single worst act of domestic terrorism in American history. Something that was terribly, terribly shocking. About a week later, a man named Kenneth Zarin in Seattle, a man who was a filmmaker kind of in his spare time and also a real estate agent, began to get outraged calls on his telephone, on his voice messages, and eventually began to get death threats. And he couldn't really understand what was going on. The man had presumably led a fairly common life and had no particular reason to have people from all over the country calling him up and threatening him. Then he discovered this. Someone had essentially adopted his name and information about him and began to post on the internet using America Online, a post that appeared to create a market, an offer to sell T-shirts with these kinds of messages on them. There are others as well, but they're all of the same ilk. And I think probably, I don't know, this may, although I've got others that will meet the normative obligation that in every presentation you have to have unreadable slides. This one may come close, but I think I've got some that will be even better later. But it said things like, putting the kids to bed, only smalls left. Second floor, ladies apparel. First floor, dead babies. Finally, a daycare center that keeps the kids quiet. And then Mcveigh for president, Mcveigh having been apprehended very quickly, so we knew who had done this. Now, the perpetrator and the motive for doing this remain unknown to this day. No one knows why somebody did this, and what we know about Zarin makes it unclear why anybody would have a grudge against him that would cause anything like this to happen. AOL took the initial post down, but these things kept happening, and AOL failed to do anything else by way of trying to at least eliminate this set of posts for quite some time. So eventually, Zarin sued AOL for negligence, and that suit was dismissed on the basis of Section 230. The suit was filed in the Eastern District of Virginia because America Online was headquartered in Northern Virginia. And so the appeal then went to the Fourth Circuit Court of Appeals. And that decision by Judge Wilkinson, who was then and is now a very well-known, very well-regarded conservative jurist, that decision affirmed this very broad reading of Section 230 immunity. And that precedent has been followed ever since. The Supreme Court has never addressed it, and it has been followed quite extensively by other courts as kind of the definitive way of understanding Section 230, that the immunities are absolutely. Now again, we have something that may be very hard to read, but this is an ad for a company called Backpage. Backpage was an online classified website with an adult entertainment section. Probably more accurately in terms of its place in the world, it was an adult entertainment proposition that also had some classified ads that dealt with other matters. But among other things, it facilitated sex trafficking. And its content moderation efforts really didn't make any serious effort to discourage it. In fact, evidence later indicated that there was a really strong effort to, on the part of Backpage, to elide any serious activities that would diminish the money it was making, essentially selling ads that involved sex trafficking. The case was brought by three Jane Does, three individuals who didn't disclose their actual names in the complaint. And this is what they said. They were all under the age of 15 when this happened. One alleged she was subject to rape over 1,000 times, another over 900 times, and the third, on numerous occasions. So you have plaintiffs that in some genuine sense, you would think would be about as sympathetic as they could be in terms of seeking some kind of relief. In the appellate decision, Rick Stearns, Judge Stearns here in the district had dismissed the case based on the precedents, and the appeal was brought to the First Circuit, and the plaintiffs were represented by Ropes and Gray, which is about as a blue chip law firm as exists here in the Commonwealth of Massachusetts and much more broadly these days. So the plaintiffs had first-rate legal representation. But the First Circuit panel, which included a former Harvard Law School professor, interestingly, a man married to an affiliate here at the Harvard Kennedy School, and also included former Supreme Court Justice David Souter, ended up affirming the dismissal unanimously. Now, again, in doing it, and this is fairly common in these cases, and you know, this is a relatively recent case. This is a 2016 opinion, and so a lot of water has passed under the bridge between the 1997 Zarin case and this one. And in terms of sort of appalling factual settings, Zarin and Jane Doe are, you know, plenty adequate in terms of appalling, but there were many others as well. There have been cases, for example, of the kind that Mark McCarthy yesterday at the study group mentioned, involving kind of hideous harassment of somebody using the Grindr platform. There have been others involving people accused of being directly descended from Nazis, and as a result having all kinds of looted art from the Second World War. There are cases involving facilitation of activities by Hamas, again, where the platform immunities have been regarded as entirely adequate to provide the immunity. So the net of this is that you have today a very, very strong collection of, let's see if we can cause this to progress. Very, very strong collection of decisions that are protecting the platforms from individual concerns. But meanwhile, over the 25 or 26 years of Section 230, the problems have obviously expanded enormously from the personal to the societal. And so today, we have serious problems with the proliferation of misinformation, obvious case of the moment involving vaccines and the question of whether or not they're safe and effective. Let's see if we can. We've got foreign influence operations. We know that the open mic is being used by various other countries to have some deleterious effects on our election activities, but also our social cohesion. There's hate speech that is targeting various ethnicities, religious groups, and all the rest that goes on essentially unchecked. And also we have radicalization. We have things that are available on the internet that cause some people to become radicalized to the point that they basically will engage in violence and other antisocial acts. So unfortunately, a whole series of problems that have taken on a much broader scale than just the individual damage to unfortunate individuals. So we now have a global problem. And we have here one of the centers of Russian active measures, as they say, against the United States and against Western Europe. That's the Internet Research Agency building. I think they may have since moved, but in St. Petersburg. rather nice building in in a nice city where people employed by an oligarch who's awfully close to the president of Russia basically engages in submitting all kinds of material into the internet bloodstream that is designed to affect elections, to create social problems and arrest. We in the United States occasionally indict some of the people who do that, which in part, frankly, is an interesting reflection on the abilities of our national security agency to identify people at a distance. But in any event, this is one source among many. I mean, there are people in Shanghai and elsewhere in China who do a lot of this. There are people in North Korea who do some of it. There are people in Iran who do some of it, and no doubt elsewhere as well. So it's a big problem. The second is, a truly horrifying problem of the moment, which is that these platforms also can be used and are used to create sectarian divisions and sectarian violence, which goes way beyond the kind of social cohesion in general that we in the West are concerned with. And it has happened notoriously and seriously in India. It's happened, obviously, especially in Myanmar in recent times, where members of one or another religious groups, ethnic groups, and so forth are targeted, and where sometimes intentionally, sometimes not, this leads to just terrible, terrible outcomes. About 10 years ago, when I was the State Department's ambassador for these tech matters, I had the opportunity to have a full and frank conversation with my Indian counterpart, the Indian Minister of Communications, who was not happy that Facebook had been used in a circumstance where the Hindu and Muslim communities in a particular geographic area were incited against one another and where people were killed. It turns out the minister, in his non-government role, was a very well-known and well-regarded Supreme Court advocate. And after listening to him for about 5 minutes, I could see why he enjoyed his really good reputation as an advocate. He was quite articulate in terms of his unhappiness and his government's unhappiness, and honestly, he wasn't much mollified by anything I could say about Facebook not intending to do any harm. He didn't think that probably was sufficient. But these are terrible problems around the world, and unfortunately, they're ongoing terrible problems. And the question is, what can we do about it? We'll look into that a little bit in just a moment. So what we find is, as we in the West certainly attempt to come to terms with this sort of thing, is an interesting set of differences. We have shared values in terms of freedom of speech with a great many of the Western countries. And by Western, obviously, I'm talking not just geographically, but also in terms of commitment to what today we would call liberal democracy. So we have a large number of countries that have suffered problems under essentially the open mic business model, and they're trying to figure out what to do about it. And just to limit this to the Western European efforts in the United Kingdom and in the European Union, you can see some very important distinctions between their constitutional arrangements and the US constitutional arrangements. And they come both in terms of the starting point, which is in Europe, various countries have limitations on speech, on essentially making certain types of speech illegal that we don't. So you have a rather broader set of categories that are available to European policymakers in terms of trying to deal with this problem. Secondly, they have the opportunity in Europe to add to those categories. They don't have to go through a process that is essentially a constitutional process, but they can add to the categories. And the reform proposals they've made, as we'll see in a minute, tend to offer greater assistance to citizens who have been disadvantaged, who have been aggrieved in one way or another. So you have, in a sense, a more activist approach to trying to ameliorate the situation. For us in the United States, you've got limited categories of illegal speech, and we have, and this is really quite important for our US concerns, our reform proposals, for the most part, simply are intended to make it a little bit easier for individual citizens to look out for themselves. Not that the government will intervene to look out for them in general, but to look out for themselves. And in general, what this means, it means more than just this, but generally what it means is to make it easier for citizens to bring tort claims, to bring claims in the nature of I've been harmed by either negligence or by willful behaviors that defame me, that create emotional harm, the other kinds of familiar tort possibilities. These are very different, and we'll see in a minute, very different things. So we have a picture of the barley mow in Brussels, where the European Commission holds forth. And it's worth taking a look at what it is proposing in the Digital Service Act. This remains a proposal, but it is intended to follow on and amend the e-commerce directive of the year 2000. As I mentioned before, the e-commerce directive followed our section 230 in terms of saying if a platform is passive, it's immune. The Digital Services Act doesn't propose to change that. It continues to say if a platform is completely passive, it enjoys immunity. However, there's a lot more to it than just that. It basically is something that has followed on extensive study, extensive public comment. Some of that public comment are things that Tom and John and I and Gene Kimmelman, who was helping us previously, have drawn upon in terms of our own proposals. So they've spent a lot of time and effort trying to understand what the problem is and how to contend with it. And the Digital Service Act is now undergoing parliamentary review. It is likely that review will be finished up next month or in early 2022. And then something called the trilogue process follows on, in which the Parliament, the Commission, and the Council, that is the presidents, as it were, of the 27 European Union countries, will have to come to an agreement, but there's a pretty high probability they will be able to. And it's likely this thing will become law in 2023. Now let's take a quick look. This is a characterization. There's a lot more to it than this, but there's an awfully serious set of issues associated with it, approaches. One is, apart from continuing the platform immunity, it is going to require greater transparency on the part of the platforms. So they're going to have to essentially expose a great part of their internal workings for public examination. There are going to be takedown requirements, so that if somebody discovers that something is either illegal or is in some other sense actionable, they will have very limited amounts of time to take these down. This will be true both in terms of the governments pointing out that there's something that it wants taken down. That will happen more quickly, but even a private citizen can raise issues, and within a relatively limited time frame, the platform is going to have to address those issues, and if it agrees that there's a problem, take the material down. Now, one very important point: the question of legality or not is a subject of both European Union law, but also national law. And again, you can see from one country to another in Europe, there are going to be differences in terms of acceptable speech. So the obvious example, the one we Americans always advert to, is in Germany, anything related to the Nazis is illegal. Now, in other countries, that wouldn't necessarily be true, but they will have their own sensitivities. And again, in the nature of things, and this is just unavoidable, once you begin to deal with speech as legal or not legal, there are always dangers that the existing political apparatus will use it to advantage itself rather than the broader society, but it's just a risk inherent in this. In addition, the biggest platforms, by which we mean essentially the US-based platforms, have special requirements. And they essentially have to independently make risk assessments about whether or not the use of their platforms is going to create a problem. Those risk assessments, when they basically develop possibilities that are very serious, obliges the big platforms to make mitigating efforts to basically mitigate these problems. And there's also an outside auditing requirement that is intended to underscore or reinforce this sort of self-examination plus mitigation business. Now, it is interesting, and again, especially interesting for an American lawyer, to consider that among the things that are to be considered are the influence in shaping public opinion and discourse, or things that can cause societal or economic harm. These are awfully general statements against the First Amendment jurisprudence that we in the United States have, but this is something that is very likely to become law, as I said, in the year 2023. And it is likely to become very influential in terms of how Western democracies think about content moderation and the limitation of speech on big platforms. But it's not the only place this is happening. As a result of Brexit, the United Kingdom has to undertake its own efforts. It was probably inclined to do it anyway, but it now no longer relies upon jurisprudence coming from Brussels. And it has something, again, that I know we talked about briefly yesterday. I think Mark McCarthy spoke about briefly yesterday, which is the online safety bill. This is also a work in progress, but in the nature of the British system, it is very likely to be a work in progress that's going to see its way into codification relatively quickly. And again, as with other of these kinds of things, this follows on very extensive efforts at review, serious scholarly looking at the problems and the possible solutions, and has come to the following general approach. Ofcom, the communications regulator, the telephone regulator, broadcast regulator, is going to be the regulator responsible for this kind of concern, online harms. It is going to use codes of conduct that are going to take general requirements and make them more specific in terms of what is to be expected. And ultimately, civil and criminal penalties are going to be available if, in fact, there are violations of the requirements. Now, in its specific terms, the online safety bill addresses terrorism and child sexual exploitation and abuse. That's, in other words, illegal speech, things that virtually everybody in the world agrees is illegal speech. But it has another set of provisions that are really quite remarkable in terms of, again, our jurisprudence here in the United States and maybe more generally, because it also addresses the question of harms to children and adults where there are significant adverse physical or psychological impacts on ordinary people of ordinary sensibilities. Now that is an incredibly general statement, and it's a statement that obviously is vis-a-vis what we would normally think of as legal speech. So what the United Kingdom is saying, if assuming the bill has actually passed, goes forward and and includes this, is something that is a very, very significant expansion of an effort to control what we would probably all agree is harmful speech in one form or another, although heaven knows at the margins in terms of something that might upset the psychological perspective of adults of ordinary sensibilities would be something I think probably that wouldn't get past the Supreme Court here in the United States. So what are we doing? We're proposing a lot, and I've picked out just three things. And the main thing to be noted about this is most of them increase carve-outs. Most of them say we want to reduce the immunity available for particular subject matters, rather than doing something that is in some sense more fundamental. Now, the PACT Act, and there are a whole lot of others, so heaven only knows what might end up moving but in the Congress, but the PACT Act actually does increase platform transparency if it were to pass. So it is in fact trying to affect, in that sense, the business model, trying to say the business model is going to have to be adjusted by new requirements. And there are takedowns for illegal speech, which isn't terribly surprising, and also takedowns for activities that violate the policies that the platforms be required to publicly make available and adhere to. The other, a couple of the others that are really interesting are, and I should say the PACT Act is bipartisan. Senator Schatz from Hawaii and Senator Thune, who is the #2 ranking Republican senator, are sponsors of this. The other two increase the carve-outs, but they do it in rather different ways, or at least they use somewhat different levers in terms of trying to increase the carve-outs. The Safe Tech Act adds a lot of subjects to the subject matter that would not enjoy immunity. And among other things, it's interesting because its sponsors include Senator Mark Warner, who is somebody very familiar with high technology issues, a real leader in the Senate when it comes to that, in part due to his familiarity from these matters when he was in business. And Senator Hirano from Hawaii and Senator Klobuchar, who again has become a very important figure in terms of her committee assignments in the Senate. And then the third is one that really ventures into, in a way, a more fundamental area, because it's titled Protecting Americans from Dangerous Algorithms Act. This is a bill introduced on the House of Representatives by Representative Eshoo, who represents Silicon Valley area, and Tom Malinowski from New Jersey. Tom served an important position in human rights in the State Department in a prior life before he became a member of the House of Representatives. And what it would attempt to do is basically say that there are going to be carve-outs for algorithmic amplification of certain kinds of behavior. So if the algorithms tend to cause the dissemination or amplification of particular kinds of conduct, those would lose their immunity. Those types of conduct would lose their immunity. Now, it's very, very hard to predict anything is going to pass here in the U.S. along these lines in this Congress, both because this session is very close to an end, and the second session will be obviously seriously affected by issues of the coming election. So there are two unavoidable questions here for the people who are students at the Harvard Kennedy School. For you and for the generation that is essentially yours, these questions are unavoidable. They're going to have to be answered. They obviously are, in addition to a handful of questions about things like climate and other minor issues that my generation is leaving for your generation to solve, but they're unavoidable. They're going to have to be dealt with. And the hard reality is there may not be stable answers for any of these questions. They may have to be dealt with continuously. So what are the questions? How do we balance free expression and social cohesion? What's the right way to think about that? And the second question is, what institutional arrangement best resolves question one? So how do we deal with the necessity of trying to find an optimal way of letting expression be as free as possible without having it really damage the community? Now, for the US, that's a First Amendment question. And one way to think about the considerations is to think of two that are pretty widely apart, but very well known. The first is Justice Brandeis' statement that in general, except in cases of dire emergency, the right response to speech is more speech. And that is probably today, if you were to poll First Amendment experts and lawyers who may not claim complete expertise but are familiar with it, that's probably the majoritarian view. The second view is one from Justice Robert Jackson, whose dissent in this particular case is often summarized by the following slogan: "The Constitution is not a suicide pact." Now, Jackson was a man of sort of practical considerations, because before and then when he was a justice of the Supreme Court, but prior to that, he had served as both Solicitor General of the United States and Attorney General of the United States. But in the midst of his service on the Supreme Court, he took a leave of absence, and he was the chief US prosecutor at the Nazi war crime trials in Nuremberg. So Robert Jackson was a man who, to put it mildly, had seen the worst, probably, that human beings are capable of. And as I say, his concern that we ought not let our sort of abstract ideals necessarily overcome various considerations of practicality is one that also needs to be taken seriously. So we have the following recent statement from Peter Pomerantsev. Peter Pomerantsev is a journalist who, among other things, is a British citizen, but born in the Soviet Union, and who worked in Russia for a time, who wrote a book with the wonderful title about his experiences in Russia, "Nothing is True and Everything is Possible." And it is unfortunately maybe a summary to some extent of a mindset that says there are alternative facts, or you can believe whatever you want. You don't really have to worry about being anchored in fact. But the thing that is arresting about what Pomerantsev had written just recently is this: one real person saying one unpleasant thing is fine. But when a handful of trolls pretend to be thousands of non-existent people saying the same thing, that is something different. And I think that in many ways summarizes the complicated problem that this generation of Kennedy School students is going to have to contend with. So here we are. Europe has opted for regulatory arrangements. It is getting very, very close to codifying these. It sees a necessity for specialized expertise in terms of dealing with these problems. It basically is in a position where it has flexibility under its constitutional arrangements, whether we're talking about Brussels or United Kingdom, to adjust certainly not on the fly, but to adjust at least as circumstances require. And they provide assistance to aggrieved citizens. They provide help to people who need it, who have been in some sense damaged. And here in the United States, we continue basically to rely upon individual citizens to vindicate our rights when it comes to these things. Some of the proposals make it easier for individual citizens perhaps to bring actions against digital platforms, but we are asking an individual using, you know, the centuries-old approaches of tort law to try to make things better. And these are plainly very different approaches to a basically common problem. My own suspicion is that in the actual reality, because the European efforts are appear to be so far advanced to the US efforts, that just as with the privacy laws and GDPR, it is likely that the European efforts will provide a very important frame for whatever the US ends up doing. Again, subject to the reality that our First Amendment is a unique proposition in the world and will impose some real limits. For those of you who are following our digital platform project here, you will note that some of the things I emphasized, not so incidentally, conform to some of the things we think are a good idea. We'll keep working on that, but next month, John will explain what the antitrust laws can do for us in terms of helping with these problems. Thank you very much for attending and listening to this.
I know we're at the witching hour, but I think we have a bit of